Good morning, Phil. It's good to
Good
see
morning,
you.
Ashley, and good morning to everyone watching, well, getting ready to watch the closing arguments here in the Lindsay Clancy trial. We appreciate you guys all watching with us here at MK True Crime. So throughout the day today, you'll have the various hosts from the various shows coming in with sort of real time reaction and analysis. We've got one eye on the chat here in the in the YouTube chat, and so we'll be able to take a look at that, and we may very well be participating in that chat, and we may answer your questions here on air as well. So, with that, Ashley, what do you expect to see kind of right out of the gate here?
Yeah, I think it's going to be an exciting day. We think they're probably going to get started. The judge has been taking the bench around like 9:30 is my understanding in the morning, 9:45. So I think that's probably when we'll get started. And just to kind of walk everybody through what to expect on a day like today with closing arguments, the state has the ability to go last. They get the last word, unfortunately, for the defense. That always, ticks me off, but that's the law. So we'll probably hear from Kevin Reddington first, and then we'll probably hear from the state last. Now they can choose, they can switch that up, but that's typically how it goes. And after they argue that, then we're going to hear what's called jury charges. And I know a lot of folks had asked about that. And again, we're monitoring the chat. So if you do have any questions, let us know. But a lot of folks have been asking, what are jury charges? What does that mean? Why don't they do them before? They do pre-charges at the beginning of a jury trial, but the pre-charges are not based on the law. And, someone posed that question and I was thinking about it and I was like, the reason that they do that, I guess, really is they don't want a jury to prejudge the evidence. And you also don't really know what charges are going to fit until the end of the case. Like yesterday, they had what's called a charge conference, and the judge gave this controversial charge that the defense asked for of manslaughter. And, the judge can't make that decision. The lawyers can't really make that decision until after all the evidence, because what the law says is that the judge has to determine if there's any evidence to support that charge. So if there was no evidence to support a charge of manslaughter, he wouldn't give it. So yesterday, I think most people think it's a win for the defense to get that charge because it's kind of what I would refer to as splitting the baby. And a lot of times when we have juries, this happens all the time. They love to do what's called split the baby. And that really is where they can't agree. Maybe you've got one or two that's saying, oh, I want to go guilty, one or two that are like, I definitely not guilty. And those two are like, I'm not changing my mind. And someone in the middle will come in and say, okay, let's kind of moderate this. Let's mediate. And they try and get them to meet in the middle, splitting the baby with a lesser included charge like manslaughter. So I think we may see something like that here.
Well, they say that, well, who's they? I mean, we in the business, we say that everything is in these trials is won or lost all the way back in jury selection. And so a lot of times when I'm getting ready to do a closing argument, I wonder if anything that I say is going to make any difference at all. Now, because who you put on the jury really sort of does decide things. But I suspect in this case, Ashley, there are a lot of people who might be on the fence here.
Yeah.
I think there's probably a number of jurors who think, well, all right, she clearly has some type of mental illness. She had something that was in some type of an acute phase at the time that she took the lives of her children. And so a lot of these people are like, well, but does that still mean, though, that she meets the legal definition of insanity? Because merely having a mental disorder or even a crisis or even bipolar or severe mental illness doesn't necessarily meet the requirements under Massachusetts law. And by the way, for those of you who subscribe to the channel, and we hope you all do, when today's episode of the MK True Crime Show that Ashley and I recorded yesterday, it should drop around noon today. We talk a lot about the standard that is required in Massachusetts, and basically once the issue is raised in the trial, Ashley, as you remember, the burden kind of shifts to the prosecutors to go back and disprove all that, right?
Yeah.
So because of the way that the burden is placed on the state, and the judge will tell the jurors that during the judge's instructions after the closing arguments, that's the kind of thing that could pull someone over into the not guilty camp. Like once they hear the judge say, all right, well, I was on the fence. I think maybe she had a mental illness, but she was still, participating. She was planning. She was taking actions that showed that she was thinking about it and she was preparing for it. But now that I've heard the judge tell me that the prosecutor has to disprove this by, beyond a reasonable doubt, then hey, I guess my duty is to acquit.
Yeah.
So these lawyers, when they do their closings, they know they've got a copy of the judge's instructions already. So they know exactly what the judge is going to say. And so they will tailor their closing arguments to what they know the judge's instructions will be so that they can pull any jurors that might be still, able to be pulled to their side. They'll pull them over that way because they use those charges. And you may hear them actually referring to the judge's charging instructions during their closings.
Yeah, no, you do. And the jurors actually sometimes use them when they're back in that room arguing with each other to try and convince each other ways to go, because it's really what happens when they go back in that jury room. They argue with each other and they try to convince the other side of their position, if there is another side. I saw a couple of the questions. One of the comments was, the trial's gutted me for so many reasons. Yeah, same. I mean, this is like hitting everything really. But being disturbed by what looks like a lack of evidence, lack of investigation, I completely agree with that. And I think that is something I talk about that all the time in my own cases. When I'm getting discovery, when I'm talking to the prosecutor about a case, when we're reviewing discovery, like, why did you not test that? Why did you not look at that? Because a lot of times I feel like the law enforcement officers just kind of have blinders on and they're like, oh, they confessed. Slam dunk. We don't need to do all that stuff. Well, jurors want answers. I want answers. I mean, I think that's natural. If you're trying to put my client away for life, you need to do all the investigation. It's not that hard. And so I think that's really frustrating. And I do think that the jury will probably be upset about that. I always say that if there's questions, you got to hold that against the state because they're the ones that are supposed to have all the answers. They've got all the ability to test all the evidence. And so that may be something that the jury considers here, the lack of evidence. It's crazy because there's evidence that she did it through her own mouth and there's evidence of how it happened. But you're right, they didn't really test a lot of things. There were a lot of things that just unanswered questions. And I think that's why we're seeing all these, what we call conspiracy theories, because there's so many unanswered questions. And that bothers me. There's a jury charge that says if your mind is unsettled or wavering, that is a doubt of the law. That's a reasonable doubt. And so if jurors' minds are wavering or unsettled, they got to vote not guilty.
It is a doubt for which a reason can be attached. And, what I do when I try cases, I keep a separate legal pad off to the side.
Yep.
And I anytime something comes up in the trial that I want to remind myself to go back to the jury at the end, and I'm going to say, ladies and gentlemen, the judge is going to tell you about reasonable doubt, which is a doubt for which a reason can be assigned. And I pull up this list, and it goes, and I start rattling off the things that I think might create reasonable doubt, even if it's one little nugget here or nugget there. And I remind them that any one is all it takes. And I've just given you 35 of them off this notepad. These are the ones that are in my notes. You may have other ones in your notes. And so reasonable doubt is a very powerful argument. There's going to be some jurors who are going to have a hard time getting past the graphic nature of some of this evidence and the testimony in the case, because it is about the loss of lives of three innocent, sweet young children. And I've been watching how some people on social media, if you use that as a barometer, they kind of vacillate. So a lot of people started out with a lot of sympathy towards Lindsay Clancy, and now after they've heard some of the state's experts, they're thinking, well, okay, well, she maybe she had a mental health problem, but she was still able to logically and coherently plan and execute this deed, and was able to use some subterfuge in the process. I mean, what I'm referring to is, planning for her husband to be gone and being able to be on the phone with him and all these things. And so this is causing a lot of people who initially were like, oh my God, she's a victim
Mhm.
of the healthcare system run amok, and being overdiagnosed and over medicated. A lot of people are coming back to, well, wait a minute, based on her conduct, things that I've seen in this trial, notwithstanding any mental health issues, she knew what she was doing.
Right.
So there's going to be, I think, some people on the jury that may have some hard opinions
Yeah.
on either side, and I suspect we're in for a long deliberation.
Well, we've got someone in the chat was mentioning that the thing that gets her is that she sent her husband on errands and was on the phone with him, knowing what she
Yeah.
was going to do. I think that's a problem for a lot of people. And that's one of the things I kept trying to listen to with the testimony of the experts, how they explained that with psychosis. How she can be able to function. I think that's a problem that a lot of jurors are going to have. To me, at the end of the day, though, she didn't, I didn't see any evidence. I didn't hear anything indicating that she wanted her kids dead. Nothing, and everything I heard was that she's a good mom. Everything I heard was that she was trying to be a good mom. And I know the state doesn't have to prove motive, but without any motive at all, it kind of supports that she is insane, because someone who's trying to be a good mother is not going to kill their kids. Like, you have to be insane. It's almost so atrocious and so outside the realm of reality that she has to be insane.
Well,
So
to play devil's advocate just for a minute, I
yeah.
mean, anybody that kills their children has to have some degree of mental illness, right?
Definitely,
I mean,
definitely.
oh, by the way, Ashley, you have some. I'm looking at your fan club over here in the chat room. Look, if you're not active in the chat, get over there, because
Yeah.
we're looking at it. Where it says, someone's here says, came here because Big Merchant is my favorite. Okay, so
I
you
love it.
got. So it didn't mention me as
That's
it being
awesome.
anybody's favorite. So anyway, it's you. But then, yeah, I guess it's a she. I don't know. They ask, why didn't the judge formally ask LC if she wanted to testify in her own defense? Isn't that a formal process? Um, if and yes, the judge is supposed to do that. Actually, when did that happen?
So that should have happened yesterday, but it might have happened at the beginning of the state's case. My guess is it probably happened yesterday during jury charges.
Yeah.
Typically, that's the last thing that the judge will do, just to make sure that they understand. And the reason that the judge does that, a lot of folks don't understand this. Most decisions during a trial are considered strategy, and they're a decision that the lawyer ultimately makes based on conversations with the client. The decision whether or not to testify, though, is one of those very rare things that is the client's and the client's alone. So they take the advice of their counsel, but they've got to make that decision. Where, just for example, am I going to cross-examine this witness and how? That's the lawyer's choice. You're going to talk to your client about it, but ultimately that's the lawyer's decision to make. But whether or not the client testifies, it's the lawyer's choice. So it's just a little bit different, and that's why the judge has to actually do that and put that on the stand. You know, I saw another comment in the chat about these experts and how little experience they had really in postpartum work. And that was one of the things that really bothered me also. I felt like the state could have done a better job of finding relevant experts. They found people who were, forensic psychiatrists, forensic psychologists, but maybe they didn't have relevant work in this area. And I thought that they could do a better
As a
job of that.
prosecutor, I would, like, for example, to your point, I would not have brought someone who is a full, like, part of the FBI's
Right.
behavioral analysis unit, because they work literally for the FBI. So, you can say that witness goes in with something of a law enforcement bias, right?
Hmm.
You want, whether you're prosecuting cases or defending cases, you want your experts to be highly qualified, but you want them to not come across as being biased in favor of one side or the other. So,
Yeah.
I've I have seen I've seen cases where in like a local prosecution where they will like they're trying to say that somebody's in a criminal street gang, so they'll bring a police officer from their own department who they say is qualified as a gang expert
Right.
to then tell the jury that yeah this proves that the person was in a gang. It's almost like a self-winding clock, right?
Exactly. Yeah, it really is. And I I can't help but wonder if some of the jurors are going to think what I thought, which is they couldn't find someone who specialized in
Yeah.
postpartum psychosis, postpartum depression that would support their theory, because the doctors that the defense brought had more relevant experience in my mind. And, this is kind of a niche area, but there are doctors out there. For example, there are doctors that specialize in OCD. There are doctors that specialize in mood disorders. There's definitely different doctors that specialize in different areas of study. And there are doctors out there that specialize in postpartum issues. There's definitely experts in that. And my guess, just a guess, is that they could not find someone that would testify that would support their theory. I don't know if that's true or not, but I think that's what the jury's going to think, because these folks seemed a little bit out of touch with that area. I can say that because I'm a woman. Just seemed a little bit out of touch. And that was one of the things that my paralegal and I have been talking about all week, because those that watch our show know that, I'm in this room, she's in that room, and we're screaming at each other when stuff happens about, oh my God, they just crossed about this or something like that. And both of us, we both have kids, we've had babies, we've both had postpartum issues. I mean, I think most women have had some mood swings after postpartum. It's pretty normal, whether it's, postpartum depression or whether it's just hormones. And so I think a lot of women think that, well, you couldn't find a female doctor who had some relevant experience.
Yeah, there's no question that at least the women that I've talked to about this case seem to be very plugged into it for all those reasons. Postpartum is real. Postpartum is the kind of thing that I think men need to be very sensitive to, and not be dismissive of, because if if your spouse or the mother of your child is experiencing this, you need to be mindful of that, and maybe pour on some extra support. And I think that a lot of times women do not get the support that they need when they are experiencing this very real problem. And so that's why this case is resonating with so many women and mothers everywhere. We go out to dinner and we have casual conversations. People know me from this program or otherwise, and they'll say, "Hey, I know y'all are talking about Clancy," but then they always want to get into a conversation about, postpartum. And so I think that this issue is one that's really resonating with so many moms out there. And if you have enough of those moms on the jury who it's resonating with them, and I'm sure there are. Was it like, how many women do we have on this jury?
Yeah, so they've got the jury, how it works, and I think there's 12 women and 6 men or something like that. But how it works is some of those are alternates, and the judge doesn't tell those people until the end. And there's a reason for that, because if you were told at the beginning you were an alternate, you may be a little bit less engaged in the trial. So they don't tell who is the alternates until the very end. But my understanding from some of the courtroom insiders is there's about 8 women that were actually early enough up in the selection process to be on the jury. So I think there's there's a fair representation.
If there's 8 women on there, I think that's an edge to the defense.
Yeah, I do too.
Yeah,
I do too.
I mean, this is a tough trial. I mean, it's obvious that it's invoked a lot of thoughtfulness and passions, I guess, on all sides of the folks that watch trials, the folks like us who are in the true crime business. We see people who feel very strongly that she's guilty, that she took the lives of these children, and that's really the end of the analysis. And then we see people on the other side that very much are like, well, she had no support, she was over medicated, she was overdiagnosed, misdiagnosed, the healthcare system failed her, and so you've got people on both sides. Now, what I think is going to happen when the jury hears the judge's instructions on how to apply Massachusetts law, then they are going to the people on the jury are going to have a little bit harder time. We went through this, and if you please, I want you to watch the MK True Crime Show on YouTube when it drops a little later today. But Massachusetts, we got into this, or we will get into this, as you'll see. We recorded it yesterday. Massachusetts doesn't call it the insanity defense. The legal name is lack of criminal responsibility. And it goes like this: a person is not criminally responsible if at the time of the crime, he or she had a mental disease or defect. Check. We got that one. That one's been met. And as a result, she lacked substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. So either one of those second two prongs, the lack substantial capacity to appreciate criminality or wrongfulness, or to conform her conduct to the requirements of the law. So that's where the hard discussions and decisions are going to be made back in the jury room. The basically the Commonwealth basically has to run the table on all that, or the duty would be to acquit her, right, based on what I believe the judge's instructions will be.
Yeah, I think based on the instructions, the right answer, whether it's popular or not, is going to be the not guilty by reason of insanity, just because of that difficult standard. And that's what I think we'll see from the defense in their closing. They're going to really try to empower the jurors to feel okay with that outcome, because the problem is a lot of times nobody wants to feel like they let someone off because she murdered her kids. I mean, that's a fact. She murdered her kids, and it is one of the hands down most atrocious crimes that can occur, really. A mother killing their kids is pretty much one of the most awful things that can happen. And the jury's going to have to sit with that and still apply the law.
Actually,
that's tough.
I want you to answer a question for Laura Wilson, 945 in our chat. Mm-hmm. She points out that this is a tough case. I can see it going either way. When they read Lindsay's journal, I cried like a baby. I do feel like she had big issues. Doctors failed her. But the hard question is, did she know right from wrong? Ashley, is Laura asking the right question?
And that's one of the right questions. If she had the ability to appreciate right from wrong at the time, if she was criminally responsible. I mean, that's one of the relevant questions. How her mental illness played into that. And that's really what we call the ultimate issue in this case, is whether or not she understood right from wrong and whether or not she was able to conform her behavior at the time to legal behavior, which obviously she didn't conform it to legal behavior, but was she able to, or was she overwhelmed by some mental impulse? I think it'll be interesting to see how the jury handles the manslaughter charge, because what the law says and how the jury treats things are two different things. Manslaughter is kind of, a gap almost, where they don't have, or they didn't in the charges have an alternative, or you could say, well, she was mentally ill, but she knew right from wrong.
Well, even if she knew right from wrong under the law, as I understand it here in Massachusetts, even if she knew right from wrong, or to use Massachusetts language, even if she had substantial capacity to appreciate the wrongfulness of her conduct, if she nevertheless was unable, due to mental disease or defect, to conform her conduct to the requirements of the law. So you can still know right from wrong and still win using this insanity defense in Massachusetts.
Yeah, you can, definitely. And, we've got another question about if they have to, like, how the jury has to do this, if they have to determine guilt on each charge, and then if they determine if criminal responsibility applies or not. That's really up to the jury. Typically the foreperson will do that and sort of talk to the jury about how they want to do it. In my experience, most of the time they vote, at the beginning, just to see where everybody stands. sometimes they walk through all the evidence first. I've seen jurors who are like, we want to talk about all the evidence before we take any votes. So they can do either. It's really up to them. Sometimes in civil cases, they'll have jury verdict forms where they have to answer a certain question before they get to the next question. They don't do that typically in criminal cases. And the example I'd give in a civil case is if there's like damages, for example. You have to first determine if someone's liable. Then you have to determine if someone contributed to that, because you're going to determine how much money they get. And if someone contributed to the liability, maybe you apportion a certain amount of damages to them. So you'll see those step down sort of jury verdict forms in civil cases. You don't typically see those in criminal cases. The law allows the jury to debate it however they want. And so it's up to that jury. It's up to the foreperson how they want to decide this. If they want to go through, do we think she did it or not? And then if she did it, do we think that she's, not guilty by reason of insanity? How do we want to handle that? Do we think the lesser included? So typically they'll vote on the top charge and then they'll go down through lesser includeds. But I anticipate in this case, they're going to talk right out of the gate about this criminal responsibility, because that's really the central issue in this case.
Well, here's another piece of this that I think it's worth talking about. Let's say that the jury does find her not guilty, and the question that a lot of people are asking is what would happen? Well, it's not like she can walk out of the courtroom, or she can't walk, but she can't leave. She can't leave through the front door, right? So she would typically be committed for some kind of current evaluation in a psychiatric facility run by the state. And she would have to be there until a court, not a doctor, but a court finds that she's no longer dangerous, and basically can be, released into society. Right. But in many cases, confinement in mental institution can last longer than the prison sentence would have. But see, here's the thing. I mean, I don't know that she's currently insane. I think that she's currently medicated and being treated. She's, the judge and doesn't seem to have any concern that she's incompetent to stand trial.
Right.
So the question is she currently insane, or is she currently subject to being held for a very long time if she's acquitted on this mental health defense?
Yeah.
You may remember, you and I know are old enough to remember when President Reagan was shot and John Hinckley was the defendant, and he pled not guilty by reason of insanity, and he won with that. But he stayed in a mental institution for decades and decades. So, John Hinckley stayed, in prison. Well, it wasn't prison. It was a psychiatric institute, but he was nevertheless, his life was not his own. Let's put it that way. And he was locked away for a very long time. So what's going to happen to her? We just don't know. But I could foresee a situation, honestly, where if she's found not guilty, she goes into the state hospital, and before too many years, they say, well, she's fine now and she can be released.
No, they could. And, it's interesting. It reminds me of one of the cases I had when I was a baby lawyer, where I had a not guilty by reason of insanity. And I'll talk about that in a minute. But this case, I think a lot of folks are worried that she will get out. But what I think a lot of folks are forgetting is that she also is a danger to herself. So the standard is, are you a danger to yourself or others? And I think she's suicidal, and I think she's probably going to remain suicidal. So if the state wants to keep her in and a judge wants to keep her in, they probably will be able to continue to find that she's a danger to herself, even if she's not a danger to others and can keep her in. But it reminds me of a case I had, where my client was found not guilty by reason of insanity. And it was what I would consider a minor charge. It was a charge in Georgia that carries 1 to 10 years, which, it sounds insensitive, but we classify felonies as serious felonies. 1 to 10 years is not a serious felony in Georgia. And so it was one of those cases. His offer was, I think it might have been time served. It was like not much. So I really did not want him to be insane because I could get him out. I really did not want him to be insane. And he was. And so I had to get an evaluation, and the doctor said he was sane. And I was like, yes, great. Okay, we can go to court. So we go to court, and he heard voices to the point where he hid under the table at court, because the voices were so loud in the court telling him stuff that he was having hallucinations and was literally sitting under counsel table next to me. And I'm like, damn it, like he's not sane. And I knew that if he could be sane enough, and that, it was insanity and a competency thing, but I knew at that point, if I could keep him sane, I could probably get him out a lot sooner. Well, of course, he was found not guilty by reason of insanity. And he needed to be, that was the right resolution. But I remember being called 10 years later, and they were talking about releasing him into the community because he finally had met the standard in the doctor's minds about release, about not being a danger to himself or others. And I remember thinking, Jesus, it's been 10 years. This man was offered essentially a time served plea. And because he was insane, he's been held for 10 years. And I did everything I could. At the time I was a public defender, and it was just a tough case because I wanted to get him out and I wanted to get him community treatment. And I think I use that as an example because a lot of folks are like, there's no, the system's broken, the system's broken. Yeah, I mean, it doesn't always make sense. What would make sense if there was some alternative where she could enter a plea and be guaranteed some type of treatment, placement in a mental institution. That would probably make sense, if we had more community mental health centers, that would make sense, but we don't. I think a lot of people are unsatisfied with the answers.
To your point, there's Oliver Kitty 6698 says, OB nurse here. I've seen postpartum PPP, right?
Yeah.
Postpartum psychosis, and it's very sad. There needs to be more education with nurses, docs, psych docs. I really think mental health needs an overhaul. Hopefully this case makes that happen.
Oh my God, that's so true. I remember, and I don't know how it is. I've got a kid that just went to college. So I got a 19-year-old and a 16-year-old about to be 17. So, it's been a while, but I remember when I gave birth that all they cared about was breastfeeding. And I know that's probably not a popular topic at 9 a.m., but I remember they would call me. And I was like, and hey, I'll get criticized. I had made the decision. I went back to work. I wasn't breastfeeding. Long story. But they kept calling me. And I actually called them the boob Nazis because they called me so much about breastfeeding. And I was like, why is no one checking in on me? Like, all you're caring about is this, breastfeeding. Like, how's the baby? How are you doing? And I don't know if there was federal funding for it or what it was. And I'm not saying it's not a valid point. I get it. Women need support with breastfeeding. I get it. It's important and it's a good thing. But I just remember thinking that that's literally all they cared about. Like, no, I was like, you're just letting me take this baby home. I could be, all these things could be happening. And all you care about is how I'm doing with breastfeeding. And I was like, if we could put that money into maybe some other, issues, like some countries have midwives that come out to the house actually and talk, see and sit down with moms and families, and talk about resources that maybe are needed, just listen. Maybe we could put those resources into that. And then I was thinking, okay, let's think about how much the government probably spent on this trial. Okay. Let's think about all these experts and how much they spent keeping her in custody. Well, maybe that money would be better spent on some healthcare, some maternal mental health community outsource in Massachusetts. I'm guessing the taxpayers probably would rather prevent a crime than punish one. So maybe we divert the resources that the state has decided to spend prosecuting her into actually trying to prevent this from happening again. I don't know. Just a thought.
So actually a question for you. So it's 9:21 and the court has not started yet. So I know this doesn't surprise you, nor does it surprise me that a court wouldn't start on time, but I think a lot of people are asking the question, why wouldn't they start at the time announced? So what just kind of explain to our viewers and those listening, perhaps, well, I guess at this point it's all viewers. We're on podcast, but we're also on YouTube, obviously. But this is going to be for our YouTube audience. So for those watching and listening on YouTube, explain why courts oftentimes don't start on time.
Oh my goodness. So it depends on the court. And
There's a lot you can say.
I'm going to give everyone's favorite example of Fulton County because everybody loves Fulton County, which I think is funny because I call it something other than Fulton County. And I don't know if it's like AI in your phone, but you know how when you use a word a lot and your phone will automatically convert it to the word that you say. So it doesn't say Fulton. It might replace the L with a C and a K. So Fulton in my text always comes up Fuckton. Sorry, but that's just what it does. And it's true. So in Fulton County, for example, you might not get your client until 11 o'clock. You have 8:30 a.m. court and you're there and, oh, well, the sheriff has decided they're not going to bring your client until 11 o'clock. And that just seems to be okay with everybody. It's insane to me. If I was a judge, I would lose my mind if people were not there on time. It would just unnerve me. But yeah, Fulton County is not a real place. I know it's crazy, but Fulton County regularly. Sometimes they just don't even bring your client.
It's a real place. I'm sitting in it right now.
It's insane. Yeah, it's just insane. But you got to think about all the logistics, which, yes, should happen by 9 o'clock if court's supposed to happen at 9, but they got to get all the media in there. They got to go through security. There's usually one entrance. Everybody's getting, through security. Everybody's getting their seats. You got to get the defendant there. You got to get all the bailiffs, everybody there. And it just takes a little bit of time. And so that's probably why it doesn't start right on time. My guess is that the judge, gives everyone a little bit of time to be all ready. And what typically happens is the bailiff goes and tells the judge when everybody's in place. So, all the actors come into court, they fill the courtroom, everybody's ready. The bailiff usually checks, are you ready? Are you ready? And then they go tell the judge, you may come out. And that's typically what happens. What I personally love, this is my favorite thing ever, is when I walk into a court and the judge is already sitting on the bench. Like those judges, there's only a few of them, but those are my favorite judges. I just want to hug them. They're sitting on the bench, court's at 9, it's 8:54 and they're there and they're sitting and they're just like, they're ready. So at 9, they're ready to go. And you can tell they're reading what's on the docket. And I'm like, you know what? That's amazing. I love you.
Well,
that's
I know
so
this
great.
is not happening in this case, but my biggest pet peeve is that, you show up ready to do your thing, whether it's closings or whatever you got planned. You've been working on this trial, you're in trial for weeks or whatever, days on end. And you get there, you're supposed to be back at 9 o'clock and you get there and the judge has decided to take up all kinds of other unrelated business, a guilty plea over here,
Oh, yeah.
a motion to suppress hearing over there. Okay, we'll get back to y'all's case. Just come back at 11:30. I know I told you 9, but I mean, how about just, and I don't, this judge isn't doing that, but some judges do. And it's so annoying. It's disrespectful. It's rude. It's,
Yeah.
it just has, this is a symptom of just not caring about anybody else's time, right?
No, it's very true. So it's a lot of things in the chat are asking about medical records and prescriptions and all that. And I will tell you, that is one of my huge pet peeves, Phil. We don't have universal medical records in this country. And I think it's insane that we don't. And it is extremely frustrating. This case highlights it. One doctor may be prescribing something and the other doctor doesn't know what's being prescribed. It's awful. And this is a perfect case. The only time in this country that we know medications are controlled substances. So if you're being prescribed these psychotropic medications, as long as they're not what's classified as a narcotic, which is really a controlled substance, a Schedule 2, and Schedule 2, when we refer to that, that's a United States code where, the federal government schedules drugs and they say this is like a super dangerous drug. And if it's super dangerous, it's a Schedule 2. So those are the only drugs that are actually subject to this database. It's insane to me that happens. So you could literally go if you wanted to like 5 different doctors and get 5 different psychotropic medications. And one doctor wouldn't know and the other doctor wouldn't know. It's nuts. And then you've got a situation where, like in this case, where they don't really know what she's, if she's taking it and she's on and off. And a lot of folks blame the patient, but you got to remember, this is for mental illness. So it's really easy to blame the patient about compliance. But let me just tell you, folks that are mentally ill are historically awful about medication compliance. That's one of the reasons that we have these long-acting injectables that are kind of a new thing, that last for 30 days. We actually have some that last for 6 months now. But long-acting injectables, especially in the severely mentally ill population, are a huge breakthrough because of this lack of compliance. And, the evidence of the lack of compliance is shown by the fact that we now have long-acting injectables. We don't have them for most medications, but we have them for psychotropic medications because people are not compliant with their medications. And that's one of the symptoms of mental illness. Yeah. So you really need to have, these
Looks like
medical
we got
records.
some movement on the camera coming up. We may be getting ready to get started. But before that happens, if I can get in a quick plug we got 115 or 16 in this room watching right now. If you haven't yet subscribed to this channel, please subscribe. We're getting close to 100,000. And by the way, we're almost at our 1 year anniversary for when we launched this platform. And our goal is to get to 100,000 subscribers at least between now and the middle of next week, if we can. In fact, our producer just put a subscription link into the chat. But if you haven't subscribed, please go ahead and do so. We'd like to go ahead and help us reach our goal of 100,000 or more before our 1 year anniversary, which comes up in about a week. Also, just don't forget, we're also everywhere you get your podcasts. In case you can't listen to our programs on YouTube, you can listen to them in your car on the way to work or at the gym or however you listen to your podcasts. All right, so it looks like there's adjusting the camera. Ashley, could this be proof that
Maybe they're getting
or
ready.
evidence that we are about to get started, or is it just a false start?
I mean, I think we're getting close to the time. It's 9:30, so I think it could happen anytime. We have another question in the chat about if you land in the ER, can't the doctor see your records? No. They can only see them if it's part of that same healthcare system. And in my experience, they don't always read them. It's awful. I personally print all my medical records and take them with me, but I'm sane. And so, you can't expect someone who's in the throes of psychosis or depression or mental illness to do that. But I will tell you, I am like psycho. I keep all my medical records. I care for my elderly mother who has, some memory type issues. And so I'm like big on this medical records thing because I have seen her be misdiagnosed, misprescribed, and I keep track of all of her medical records and I take them with me on everything. But that, when you've got someone who's mentally ill like this, it's just a bigger issue because doctors don't always have access to those records. It's crazy, but you have to sign a HIPAA release, which Lindsay Clancy did, and that was brought up during the trial, and they have to actually request those records, and it can take a long time. It's not instant, and that's a big problem, and I think this case has really highlighted that problem.
I agree that there has to be lots of reforms. Without getting too much on down this rabbit hole, I am squarely in the camp of we prescribe too many psychotropic medications. And let me explain that. If you go to 2 or 3 psychiatrists with certain things that you want to talk about, you're going to get probably going to get different diagnoses from each one, and you're going to get different prescription suggestions from each one. And there's just so much subjectiveness built into these diagnoses. If you break your arm, you can go get an X-ray, and the doctor can see the objective evidence of the broken arm and can treat it accordingly. But if you say you're having certain kind of thoughts, well, what those mean is up to the subjective interpretation of a doctor. Looks like here we go, guys.
She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
Well, good morning, everyone. Good morning, Counsel. Good morning, Ms. Clancy. All right. The party's ready for the jury?
Yes.
All right. Bring them in.
Court, all rise. Jurors entering.
All persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting at Plymouth within the floor of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
All right. Thank you, Madam Clerk. Well, good morning, everyone. All right. Well, you know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? All right. Secondly, is there any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right. Again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right. And that just means I'm going to give the charges my instructions. All right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right. So they take a while. All right. And they can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right? So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, geez. I forget how efficient our court-offs here are. So what I'm going to do is I'm going to start the instructions now. All right? Now, so my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all of my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now. So please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged and also criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or two, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I have previously instructed you, your decision should be based solely on the evidence and the law of this case. If a defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the defendant is mentally ill, and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. Intended to kill the deceased, and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and/or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of three ways. These are that the defendant, A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those three ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, that the defendant A, intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right? And I discussed those elements earlier when I discussed the charge or the theory of first-degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right, now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first-degree or second-degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. Two, that the defendant intended the conduct that caused the death of Cora, Dawson, and/or Callan Clancy. And three, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates, a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right, so that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right, and I'll go over that a little bit later, but I just wanted to remind you of that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right, and so, counsel?
There's about 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Helen. She knows loss. And that's why we think of Cora Dawson. Loss. And that's why we think of Cora Dawson. Helen. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before. How many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. How many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell a jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something. As I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will than likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman, I guess, that's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living her life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. Subjective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one? Hanging off of the window, sliding down the house, and Lindsay screwed up, and she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat, Googling suicide, Googling drugs, Googling side effects, Googling ketamine treatments, Googling all of these drugs, Googling the effects of Tufts medications, lorazepam, sertraline, hydroxyzine, lorazepam, buspirone, trazodone, fluoxetine, zolpidem, myrtazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in a house with a husband and her babies, respected nurse, wife, friend, mother. Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. Put that over in the bad pile. Right here. We spent all that time showing through Dr. Lapasada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you ever played pool. I challenge you to tell this jury why we spent a week showing that she committed, your witnesses.
Counsel, address the jury, please.
Said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that, and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Lapasada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Lapasada and says, wrapped. They were just wrapped. They weren't knotted, because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Lapasada said, yeah, I saw what you did. And she walked away like if the glove won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children, to the point where he had to struggle And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective. And it shows the manipulation. This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Laposada said, you're talking about 4, 5 seconds, so somebody passes out. No, they got to have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement. Her throat was crushed. You heard the 911 tape. You draw the inference, whether or not there's a conversation about where the children are. I tried to kill myself, the kids are in the basement, all that. You determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty. And number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got the charges are before the court, you can sit there in the court, you can feel proud of yourself. Did you do a good investigation? Do you even know what this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Lousy investigation of this. Well, that's okay, because she was guilty, and they put her in the hospital, and she's the evil woman that killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges, and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers? Remember Meg Collins? She came in this court, Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital, treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major surgery of her broken, crushed spine, vertebrae, rib, thyroid. Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you've heard evidence, comes out of surgery, they are delusional. You've had anesthesia. You've had think about having a tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine. And then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about is they had to have this big confabulation about, we're going to take her off the, the healthcare process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Put that in the guilty pile. That's why she said that in a delirious state, dealing with all of these people about that issue. Put that in the guilty pile. That's why she said that in a delirious state, dealing with all of these people about that issue. But Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You heard the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no. They were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory, not mine. One of them testifies, well, they might have looked at it. One of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that you have this evidence. You have evidence of sleep aids. You have evidence in the bag. Because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it. And we held it for 3.5 years. Anybody care about it? No. You had evidence that the police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They did. In a bag when I saw it inside this thing here, and we seized it. And we held it. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated. This is a a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth, second time around, hoping for a good birth, worrying about the child and after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking. You've heard all this, not my words, witnesses' words. Into October of 22, young, vibrant, hardworking. You've heard all this, not my words, witnesses' words. Holding goals for herself. Hardworking nurse, hardworking mother would watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about it here, and you've also got manipulation because you know beyond a reasonable doubt, even though we don't have any proof. We have no burden. Heard from Sheila. Remember Sheila, the woman that's the reverend or whatever. She's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices. Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucinations. She didn't say command hallucinations. I heard voices. It was a male voice. Told me. You had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2, Mac, put him aside. You've got the other doctor as well. So Mac is, why he was freaked out when I asked him where he stayed, and the other guy looked at me like his eyes were bugging, why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective, why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests and then go back at it again with Mack and with Halbrun. And she was cooperative. She was pleasant. She was friendly. She answered the questions, and she owned what she did. Huh? She never ran from anything. She's gone through evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. They're busy. Paul Zeisel was there, literally, in Brigham and Women's, because I called him. Because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel. And I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of humane feeling to try to help this young lady? And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Tewksbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. He's a good kid. He's a beautiful soul. So you have Zeisel that has been with her all that time. You've got Sheila who's been with her all that time. You've got evidence that her mom and dad who lived in Connecticut come up and they stay and they visit with her and that they sit with her. And God forbid they actually sometimes had dinner. Remember that? They got the Tewksbury records. Boy, there's a good score. Let's go through the Tewksbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly for 3.5 years. She's acting like a human being trying to exist. But the guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet she was cooperative, she was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records, she signs the HIPAA forms, they don't know what her records are, but they know for sure what Dr. Resnick had in his report, they know for sure what Dr. Zeisel had in his report, they know for sure what Meg Spinelli had in her report, and they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her. She passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate, and more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zeisel, Dr. Conley. And they were paid for their testimony. We're all paid, like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert on malingering. You heard him testify by Zoom because he had surgery. But he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them, everyone says. They looked at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death, times 3. Has any of the government doctors rebutted that? One of them, Heilbrunn, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday, who didn't even know what killing during the course of the psychosis was. And when I was questioning him about it, he agreed, and I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why, the how, and the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect. As Dr. Zeisel said, that she was suffering from a disease or defect. As Dr. Condy said, she was suffering from a disease or defect, and Condy took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence. So you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied, according to the guy yesterday that testified, she lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she is, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard, charging, manipulating woman that was controlling, and everything in their life was controlled, and she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi testified when asked, did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Kellen, put down for a nap. Hopefully we'll nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then, that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I don't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts. You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs, and like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote. to support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time that she killed her children. You all remember this. October. This is not an evidence, it's marked for identification. It's too big, so. But basically it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? Manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callan, because she loved her children. They were her life. Manipulation. And when you consider the journals, I don't know, you ever watched the movie there, The Shining, with Jack Nicholson? Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice woman. She's testifying. She didn't know. I suggest to you that she didn't know hardly anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you got when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone. You don't measure going down the stairs. You measure stair climbing, right? That's what the testimony was. And there were 3 stairs that were climbed. Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross. What happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and it left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right? You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the bathing, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You'd think that that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave, and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live her life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was. Along with the fact that it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. And I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot, there's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, you remember there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head. And it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
All right, Como.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue is whether, at the time she killed Cora, Dawson, and Callan, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The 2 older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callan 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, you know, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for one 25 milligram pill a day for 7 days, and then to go up to the 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan from the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you two options. Either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications. She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So you can see that in a lot of the medication she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow-through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant and she's doing what she wants to do is she has this desire to be herself again. She just wants to go back to who she was, and she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's understandable. That's relatable to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking, because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, you know, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work, and that it takes time for them to get into your system and it takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took weeks for the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient, she couldn't wait. She wanted faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to NGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts, you need to stick with one provider and stick with one plan to see if it works. And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you know, you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over-medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication, and being over-medicated, taking too much of a medication or taking too many at one time. There's a difference there. And Women and Infants never says she was over-medicated. What they also don't do is turn her away. It's not that she went there and they said, can't help you, go away. They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization, where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, go away, we can't help you. And her response, well, I'm going to talk to my provider about it for guidance. And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that Women and Infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she's just, no, doesn't want to do them, and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help. But she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society and interacting with others and presenting herself as a functioning adult, a functioning mom. You know that she knew the difference between right and wrong during that time because she had those thoughts at the beginning of December of harming her kids. And she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore, didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought, that telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought, because you don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad, it's because it's wrong, it's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At each, she said no. So she's hiding it. She's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. Most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information is accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them had been out of her system for months. Zoloft she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. Only medication she's on leaving McLean is trazodone, anxiety. And that's it when she leaves there. Anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Corey's birthday party. And that's That's relatable. That's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. But she shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. But she shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. Make an appointment, pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, typical mom birthday party stuff. Everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said, seemed a little tired, but okay. The Museum of Science, you have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Codder as well. Similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen, seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report, and they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom, obviously, was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? Obviously, a very concerned, loving mom. How did Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction. And we have that text from her mom the day she leaves on the 22nd, headed back home. I'm glad to see you're doing so much better. Now her mom now wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You know, you've got this. Take it day by day. I'm here for you. We're going to get through this. But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, I'm glad you're doing so much better, because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope, because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day. Very low dose. And then she told Dr. Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis, all the way up to January 23rd. Nothing. Detailed, excuse me, about when she took medication, what she took, the amounts she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness, and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. When this is on her phone, you can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Map search to see how long it takes to get to 3V. Well, defense wants you to believe that, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the month before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have Kids Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it and then go on to 3V so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision making that Dr. Satoff referenced. And then after that, she texts Patrick, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialax and she knew about 3V and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialax? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And that's the time he leaves because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense of life experience. You're headed out the door to run an errand and someone in your home says, oh, while you're out, could you get me X, Y, and Z? And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door and she texts it to him at 5:15 p.m. And then he goes to CVS. Even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34. And then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter and it's quiet. It's quiet in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down and no answer. And he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, "What did you do?" And her response is, "I tried to kill myself." And then it's, "Where are the kids?" In the basement. It's not, "I heard a voice. I was compelled to do this. I didn't want to do this. Go help the kids. They're hurt. They're in the basement. Go save them." No. It's, "I tried to kill myself, and the kids are in the basement." And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised, her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911, he's talking to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records, you know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them, however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while, because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down, and someone there for a period of time, and then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time, and then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground. And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call, that after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well. And Patrick saw Dawson eating the chicken nuggets and green beans. So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report, you can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they have, to telling him to get it, to making sure it's in stock, all of that, and he still calls her, he still interrupts her. And then she gets the knife and she goes upstairs, and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Laposado included, it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Laposado wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. They don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted, so I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied, but even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots. And he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson. And he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted, they weren't tied. They don't just stay there on their own. And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m., because he's making the call to her at 6:09. There's not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20-odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying, would never harm her kids this way unless she was so mentally ill that she was hearing these command voices and had no choice. But that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have, moved down to her mother's. She could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted. And when she woke in the hospital, and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children.
Counsel,
Said that was all accurate.
let's move on from that.
Lindsay Clancy hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. Leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So how that works. It's a red flag that she's making up the voice. Another one is that what she said, the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance, you have to kill the kids so you can kill yourself. And then she tells the chaplain, you have to, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these three different versions. Another flag red flag, it doesn't make sense. That the voice, she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice and you have no free will whatsoever, you're just doing, your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hang yourself. That's acting on compulsion, that's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that third prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. I mean, she landed the wrong way and ended up paralyzed on the frozen ground. But you know, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to, she was trying in all these different ways, but she just couldn't get over that third prong, the capability of actually killing herself. And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died. And the order also shows a rationality, the order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callan and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking. And we didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty, she is guilty.
All right, thank you, counsel. Now, members of the jury can sit here for a while. Does anybody need a short break? I think that would. All right. So we're going to return now to the instructions that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there. All right. And what I just kind of wanted to make clear that You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second-degree charge as well. I mentioned that for some of the others, but and specifically for the charge in murder in the second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right, so I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt.
These are standard
This burden
jury
of proof
instructions
never
now.
shifts.
Donna,
The defendant is not required.
what's your
to
take
provide
of
any
what you
witnesses
heard in that
or produce
reply?
any
That rebuttal?
evidence
Well, actually,
that
it's not
she
even
is
rebuttal. It's the
presumed to be
prosecution's
innocent.
close. I'm just
The
not used to the
presumption of
prosecution
innocence
closing
shows
last
the
unless they've
defendant
also
unless
gone
until
first.
the evidence
Yeah,
convinces
that
you
is true. They do get the last word because they have
that
the
the
burden of
defendant is
proof. I
guilty
listened to
beyond a
every
reasonable
word of
doubt.
both the
It
defense and the
requires you
prosecution's
to find
closing
the
argument.
defendant
And I'm
not
going to
guilty
say this.
unless you're guilty
During
of
the
proof
trial,
beyond a
Dave, I
reasonable
think
doubt.
many of us
Your
were very
verdict,
impressed
whether it is
with
guilty
the defense
or
attorney
not
Reddington.
guilty, must
He did a
be
masterful
unanimous.
job on
Now,
cross-examination. He
reasonable
really
doubt.
brought forth
The
his
burden is
defense
on
in
the
a
Commonwealth to prove beyond a
understandable,
reasonable doubt that the
compelling.
defendant is
I don't
guilty
even
of
want
the
to say
charges
entertaining.
made
That's not
against
the
her,
right
as
word,
I
but I
just
think
told
the
you.
jury
But what
was
is proof
listening
beyond a
to every
reasonable
word that
doubt?
he said.
The term is often
In
used
this
and probably
closing
pretty well
argument,
understood,
however,
though it's
I
not
did
easily
not see the
defined.
same.
Proof beyond a reasonable doubt does
I
not
didn't
mean
see the
proof
same
beyond
from this
all
man.
possible
I
doubt.
thought the
For everything
defense
in the
closing
lives of
argument
human
was
beings is
disjointed.
open to
It was
some
not linear.
possible or
It was
imaginary
not
doubt.
compelling.
The charge is proved
He did
beyond a
not
reasonable
bring
doubt if,
the same
after you
force
compare
in the
and
closing
consider
argument that he
all of
did
the
during the
evidence,
trial. Now, I
you'll
get
have in your
closing
mind
arguments are
divided
not evidence. I
conviction
understand
to a
that. But in a
moral
case
certainty
with this
that the
kind of
charge is
weighty
true.
evidence, with
When
this
we
kind of burden
refer
for
to
the
moral
jury,
certainty,
with
we
these,
mean the highest
these are
degree of
not
certainty
easy
possible, and that
concepts
is
for a
related
jury
to
to sort
human
of sift
affairs
through.
based
He
solely
needed to do a
on the
better
evidence
job
that has been put
and bring it
before
over the
in this
finish
case.
line in the same
I
way
told
that
you
he
that every
conducted
person is
himself at
presumed to be
trial.
innocent until
Prosecution, on the other
proven
hand,
guilty,
Dave,
and that the burden
they
of
might
proof is
have
on the
won this
prosecution.
case
If you
by
evaluate
the
all
closing
the evidence,
argument.
Wow.
What do you
still
think?
have a reasonable doubt
it's
remaining,
rare
the
that
defendant
a
is
case is
entitled
won in
to
closing.
the benefit
I
of
mean,
the
that's
doubt
usually
and
by that
to
point the
be
cake
acquitted.
is baked.
It is not
Mm-hmm.
enough
But
for the
I agree.
Commonwealth to establish
You
a
know, I
probable
came
guilt.
on late
Given
in
a
this,
strong
but
probability
I
that the
thought
defendant is
the
more
prosecution
likely
did
to
a
be
good
guilty than
job
not guilty.
in
That
what I saw of the
would be
close.
enough.
Now, there's
Instead,
one thing
the
that
evidence must
still
convince you
bothers
of
me,
the
and that
defendant's
is
guilt to a reasonable
I thought she
and
did a good job
a certainty
of
that
explaining that
convinces
she
you
knew
of
the
the
difference
state
between
or
right and wrong. She
satisfies
knew
you
what she
of
did was
the
wrong.
judgment.
And in most other states, that would be enough to get a conviction because that's the standard. But not in Massachusetts. Massachusetts, you have to go further. And there's another step. You have to show that she could not conform her conduct to the law. Actually, the burden's on the prosecution. So you have to, the prosecution has the burden to show that she could conform her conduct to the law. So it's more than just not knowing or knowing what you did was wrong. You have to show that she could conform her conduct. And that's where I think there's a gap. I have not been convinced beyond a reasonable doubt. And, you know, I'm like the pro prosecution person on this show,
You're the lawman.
right? A
You're the
Florida
lawman.
lawman, right? Yes.
Special attention to anyone
But I've not been convinced beyond a reasonable doubt that she could conform her conduct to the law. I think she's so medicated, so lacked without sleep, so missing sleep, so mentally disturbed that she heard the voices she acted on. Now, that was a powerful point by the prosecutor who said, well, she heard the voices once and then she acted. And then the prosecutor went down too much in the Yates rabbit hole. You can go a little bit, but then when they started talking about another case, that's when there was an objection, and the judge said, move on. But I do think that the prosecution overall did a good job. I still don't think they closed the gap on that one part. Could they prove that she, the defendant, knew or could not, could conform her conduct to the law? So that's my issue here.
So can I push back and say, so you do not equate the items that seemed quote unquote normal in the very moments heading up to the 3 killings with an ability to conform to the law, like sending your husband out for food, like feeding the kids, like calling the pharmacy for the Miralax, like all of those things, which I think even the prosecution used the word, she was normal. You don't think those things by design or circumstantially even prove that she was not in a psychotic break? That was very much in reality. Therefore, she could have conformed her conduct to the law.
I think the defense was successful through their experts of convincing me and perhaps the jurors that you could be like a duck above the water, peaceful, normal, and then below the water, you're scrambling. And the medical experts say that you could be going through a psychotic break and still appear normal on the outside, still be lucid and cogent. And I think that is crucial because otherwise, yeah, there's premeditation here. There is planning here. But if there's premeditation and planning because she's listening to voices, because she has this history of serious psychosis, mental illness, then I have reasonable doubt. And that's my issue. Now, could she be found guilty of a lesser charge? It is a victory for the prosecution that they got the manslaughter charge in there, because I think that you can incorporate the mental illness and still find her guilty on the manslaughter charge. Whereas first-degree murder, I think it's a no-go. I would be shocked if they find her guilty on first-degree murder. I would not be shocked if they found her guilty on like involuntary manslaughter, which is now available to the prosecution.
Yeah, those lesser included are basically an off-ramp for a jury, knowing full well, we know what juries like to do. If they can't decide, but they don't want a hung jury, they will, and pardon this phrase, but they will split the baby. And they will find some way to hold her accountable, but not 100% accountable. And by either finding a second-degree murder or a voluntary manslaughter, that's the off-ramp for this jury to not end up hung. And that may very well be what they end up doing. But can I also comment for a second on, I even thought the prosecution did a better job delivering the closing argument. And what I mean by that is I love a Reddington affect. I love the pound the fist on the table. I love the jumping up and down. God knows I do enough of that myself when I'm not in the courtroom. But when it came to delivering this closing argument, that soft, steady, linear, motherly, feminine energy that the prosecution brought, I think, enhanced the argument itself. What do you think?
Agreed. And I didn't see a bow in her hair. So that was probably a good.
No, there was no bow.
Bowgate is real. Yes. So I thought she did a good job there. I did. I was watching it, and I know that in talking to you and others on the show, there's been a lot of admiration for the job the defense counsel has been doing and criticism for the prosecutor. And so when I was watching it, I'm thinking, seems pretty good to me. And it's cool to see that you felt the same way. So we'll see. I think a quick jury verdict here will inure to the benefit of the defense. I would, if it's a quick verdict. Now, usually a quick verdict is good for the prosecution, but in this case, when I think the prosecution is going to have an uphill battle meeting their burden, I think it's going to take a lot of discussion back in the jury room to get them to find this woman who seems sympathetic in front of them, who's weeping at the evidence about the deaths of her children at her own hand, and is sitting before them in a wheelchair, paralyzed for life. I think to convince them to find her guilty and possibly spend the rest of her life in prison, it's going to take a while. If it's a quick verdict, I think that's a not guilty.
I don't think we're going to get a quick verdict with this kind of evidence, this scientific evidence, the amount of evidence. A quick verdict, I think, would be almost a cop out for this jury. And I'm glad you brought up the point, because we almost forgot. Like, there is an optic issue to this entire trial, right? Lindsay Clancy is sitting in a wheelchair, so she genuinely attempted to hurt herself successfully. And there were times, I think, when the jury saw her weeping. I mean, and how could you not? Because you got to keep in mind, it's now 2026. So she's probably in an entirely different state of mind today than she was when this happened in 2024. So she's naturally going to garner some sympathy, just optically, I think, from that. But something, this is weird. But I saw, when I was doing some homework on the case, some outlet took a picture, a still shot of Lindsay Clancy, and caught something that I hadn't seen in the snippets that I watched from the trial. And that is, she almost looked pissed off and not nice. And I said to myself, whoa, wait a minute. That's not the crying, weeping person that we've seen a lot of the times in this case. And that gave me pause, for what it's worth. So if I saw it in a still shot, chances are there had to be moments like that throughout the last 4 or 5 weeks that maybe the jury saw too. And that could be rolling around in their heads as well.
Very interesting point. The jury pays attention to everything. They're very perceptive, right? Everything. And so you can lose, you're sitting there for weeks, and you could lose focus, and then all of a sudden, you let your guard down as a defendant, and then the jury sees you do something like smirk or roll your eyes or write something like being callous. There's testimony that everyone's riveted, and you're like, you don't care. So there's anything could set the jury off on you.
Right.
What's going to happen here? Has the judge, we should maybe check out what the judge is saying, because has the judge announced yet who's going into the jury room and who's not? This is like a devastating time for jurors who have been watching this trial, taking notes for weeks, only to be told your day is done, your trial is done, you get to go home, you're an alternate juror. And, they never tell the alternate jurors who the alternates are in advance. You know why? Because those alternates would be like sleeping. They're like, I don't need to pay attention. So they crush them on the way to the jury box. No, a jury room. You're not going in there. No, you're going home. And I've seen jurors cry because they've been, right? I mean, they've invested so much.
It's like being on a job, in a 5-week job interview, and then being told you didn't get the job. That 12 other people got it instead of you.
But it's random. The die is cast at the beginning of the trial. It's not because of anything they did in trial.
No, right. It's completely random. Yeah, let's pop back in and see where the judge is at.
Yeah, let's turn it up.
It's your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it at all. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying, and whether the witness displays any bias in testifying, and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing.
So I wanted to ask you, I mean, these are the standard jury instructions, which, hopefully the jury won't snooze through them. But because I have to leave in a minute, I wanted to ask you something. Do you think it matters at all that Lindsay Clancy did not testify in this case?
Well, you know that you can't refer to it as a prosecutor, so they can't ever say, wow, if she's so innocent, why didn't she take the stand? That's an immediate mistrial and sanctions before the bar. You can't allude to it. You can't even think about it in your head.
Right.
There's a scene in Spinal Tap. It says, don't touch that. Don't touch that guitar. What? No, can I look at it? No, don't even look at it. Like,
right.
So, do I think, though, but, jurors are real people. And do they think that maybe she should have testified? I think that jurors are always questioning. Now, they're told over and over again by jury instructions. They never make it a negative inference. It's their right.
Right.
I think they made, the defense made the right move keeping her off the stand. Because when you're up in the fourth quarter, why do you take any risks? Why, keep the ball on the ground? So that's to say, I thought the defense was winning until the closing arguments. And I think a lot of bad could happen when you put her on the stand. Maybe she doesn't look sympathetic after all. Maybe she misspeaks, or maybe she seems so lucid on the stand that the jury's like, this woman is predetermined, choreographed. She's calculated and cold, and that's the fear. So I think it was the right thing to keep her off the stand. But do you think differently?
No, I think it would have been very dangerous to put her on the stand unless, of course, she was going to be so blubbering that she wouldn't be able to get a word out, and the jurors might have gone from sympathetic to angry that they couldn't actually get anything from her. So It was probably too dangerous, and a smart decision to not do that. But the other smart decision, Dave, is you're going to stay here, and I'm going to scoot for now and leave this in your capable hands. Good to see you. This has really been one heck of a trial, and I can't wait to discuss the verdict with you.
Jana, it's been a pleasure. It's always good to be on with you. Thank you for coming on today.
Thank you.
All right. Well, let's see.
In your deliberations, along with all the other evidence that was presented at the trial.
I guess we'll just continue with me here then.
Now, there were a number of expert witnesses.
Let's go back to the audio and then let's talk about it.
This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge. That is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert.
You're listening to the standard jury instructions. We can turn it down just a little bit. These are boring because they're the same thing. You hear it over and over again, and the jury's got to deal with this. This is the worst parts about being a juror, because this is stuff you have to say, but okay, I guess as a lawyer you hear it so many times, but what you're hearing from the judge is that Boston accent. And I bring this up because your perceptions, your feelings, that matter a lot. It's not just the evidence, it's just how you take the parties in front of you, includes the lawyers, the judges. If you're from that area, if you're from Massachusetts and you see the judge with the thick Boston accent and the defense lawyer with the thick Boston accent, but the prosecutor doesn't have it, you may, either knowingly or not, feel more sympathy towards the defense. They sound like you. They live in your community. They're not an outsider. And it matters. It matters. I, as a former prosecutor, I hate to say it matters, because you're supposed to just follow the evidence and the law and not worry about accents. But it's human nature to sympathize with people who have your same background and history and culture and accent. And that's why, the DA in this case, I know him. I used to work with him. His name is Tim Cruz. Great guy. Plymouth County District Attorney, or whatever they call him there, the head prosecutor. He has a thick Massachusetts accent. I say Boston accent, Massachusetts, whatever. He has a thick accent, just like the judge, just like the defense lawyer. But the prosecutor he assigned to the case, those prosecutors didn't. And I wonder if that's going to play at the end of the day. You always worry as a lawyer about being what's called hometown. You go into a community where you're not a native, and it's like an away game. Is this going to be an away game for the prosecutors? We'll see. And maybe there's some interesting jury instructions we should catch. Let's see what they're doing. If you want to turn it up.
Keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence, and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts, all right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or
So the
to conduct any
consensus
research about this case
amongst
until
the
I accept
MK true
your
crime
verdict.
analysts, the consensus
Kinda wanna
amongst the
make that
MK true crime
real
analysts
clear. All right?
is
So
that
if somebody has a
Reddington
question in that
did
jury,
not give a great closing argument. And they had been admirers of Reddington defense
try and
lawyers. He had
answer
done an
by
amazing
anything
job
other than
up to
to
this point.
exhibit
It's not
the evidence
just
you've heard. All right?
our commentators.
We said-
It's also legal experts like Jonathan Turley. I was just, Phil Holloway just sent me a tweet that he put out that said Reddington's closing is a bit rambling with references to everything from the Simpson trial to the movie The Shining. It is surprisingly diffuse and at points confusing given the able defense during the trial, in my view. If somehow the prosecution wins this case, people are going to point to the defense closing. And that's rare because closings, like I said in my conversation with Jana, they're generally not determinative of the verdict. I mean, like I said, the cake is baked at that point. But maybe this is the exception to that rule, especially when you have such high expectations. Maybe that's where your high expectations can hurt you. If you flop in your closing, all of a sudden, game on. I would think it's a victory for the prosecution if they get any conviction here, meaning a lesser verdict of manslaughter. That is a victory for the prosecution in my mind. I don't think there was ever a real chance that they would get a conviction on first-degree murder, but if it happens, and I've been wrong before, then I'll have to tip my hat to the prosecution, admit that I was wrong about their overcharging the case, and I think we'll point to the closing as perhaps what led to that surprise verdict. But is it possible she can get convicted of the most serious charge? Sure. Is it probable? I don't think so. I've been following this trial, and I just think that there's plenty of room for reasonable doubt here because of the medical experts, the witness testimony. I mean, her own husband was testifying for her. And then you have the conspiracy theorists out there, the people who think the husband did it. She admitted she did it. She admitted she did it. So anyone who says that the husband really did it and they're framing her, no, she admitted it. Her lawyer built the whole case around she did it. There's no doubt about it. There's no evidence pointing to the husband. Well, he's got a new wife who looks just like her, a new girlfriend or wife. I don't know if they're married or not, but whatever. Okay, if you want to blame for that, but everyone grieves in their own way. And I would not ever want to be put in his shoes. And it proves nothing that he was somehow involved in this horrific murder. And if you listen to his 911 call, it's just so heart-wrenching. I still can't get that out of my mind, finding your children strangled to death. So we'll see what happens. This is going to be a lot of fodder for a lot of our discussions on MK True Crime. So stay tuned. Let's go back to the judge.
Back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. Now, while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating. All right, so no subcommittees in a sense. What you do as a group. All right, you do it all together. Now I'm going to get to a difficult part: reducing and sending out the jury. All right, when we impanel a jury at the beginning of a trial, we never know whether some personal emergency will
Here it
arise
is.
during the
Here's
course
when
of
he's
the
gonna
trial, which would
crush
require
the
one or more of the
spirits
jurors to be
of
excused
number of
from further
alternate
jury
jurors
duty.
here.
To
The
avoid
alternate
having
jurors
to
don't
start the
know
trial
that they're
all over
alternates yet.
again, if that should occur, we impaled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this is a lengthy case over the summer.
They're going to send 6
The time
jurors
has now
home
come
now, and
to
they're not
reduce
going to be
that
happy.
number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12. All right. And so the way it's done is the clerk will draw the alternates' names, we put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so we may, and it happens fairly regularly, they would have to substitute one of the alternate jurors into the deliberating jurors. Because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. So I put in here, fate makes you an alternate juror, don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations, and it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14. Juror number 122 in seat number 6.
They do things so differently in Massachusetts. This is not how they do it in Florida. They know the alternates in advance.
Juror number 124 in seat number 7.
It's like the reverse lottery. If they pick your number, you lose.
And juror number 245 in seat number 15.
Now, they're not going to show, or well, we'll see. I don't think they're going to show the jurors leaving. They're going to have to walk out of the courtroom. I don't think you'll see it because they want to preserve the jurors' anonymity. I think we've got a frozen screen.
There's a box for guilty of murder in the second degree. And there's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest, respectfully, that you each approach it with a mutual respect for the opinions of your fellow jurors. They have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only. Have a disposition to listen to each other, discuss. Don't be afraid to change your own opinion if the discussion persuades you that you should.
So this is still typical. There's so much power that jurors are given that if jurors want to argue and get testy with each other back there, it's not against the rules. I mean, you're not instructed to fight each other, but it's a high burden to cite juror misconduct. Now, if the juror is writing a book and has a financial incentive in the verdict, that's definitely juror misconduct. That'll be a mistrial. Or on appeal, they would overturn it. But when jurors go in the back and they argue and it gets heated, that happens. There's a lot of discretion. So that's why it's very hard to overturn a case by saying there was juror misconduct in the jury room. We pretty much let it go on back there. It goes down. It's behind closed doors. And unless there's something really egregious, some financial motive, perhaps a physical threat, you can argue and intimidate, try to isolate the person. It's 11-1. How can you hold up this verdict? It's 11-1. Why are you not letting us go home to our families? That's not automatically reversible. That's the kind of thing that goes on behind closed doors. So they're instructing the jury. I feel bad for the alternates. And it's interesting how Massachusetts does it, where they put 18 jurors there, and no one knows who the alternates are going to be until they shake the box at the end, and then they pull it out. Wow. That's high drama. So let's go back to the instructions, and then I'll
Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair. And be that as you took the oath to be, I am completely confident they'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
Okay. Well, it's 12:30. And they're about to go into deliberations. So at this point, I'm going to sign off. We're going to keep the cameras rolling, and we'll keep following this. And you can always get the verdict from us, analysis from us. We're going to keep following this whole way through. I'm Dave Ehrenberg, a.k.a. the Florida Lawman. I appreciate your being here at MK True Crime. And on behalf of Jonas Bilbor and Ashley Merchant and everyone else who came before us, thank you for watching. Keep watching our shows during the week on the MK True Crime channel, and I'll see you next time. Cameras are rolling.
else to speak to them except by order of the court, so help you God. As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place separate and apart from the other members, that you will not speak to them yourselves nor suffer anyone else to speak to them except by order of the court, so help you God?
I do.
Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jury, you have been open. Come to instruction, television.
Aye. Oh. Yeah. I think
Jurors have exited the courtroom.
All right, everybody can be seated. I just wanted to make one comment, and it really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing, it's intellectually challenging, it's physically exhausting. So I just wanted to commend all three counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
Do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get
All right. What we're going to do is I'm going to bring the jury back and just excuse them till tomorrow morning. Okay? All right. Yeah.
Court, all rise. Jurors entering. This court's now in session. Be seated.
Your Honor, present before the court, we have 12 deliberating jurors and 6 alternates in the matter of Commonwealth versus Lindsay Clancy. All other parties are present.
All right. Thank you, Madam Clerk.
You're welcome.
What I wanted to bring you in. It's been a long day for everyone. And so what I'm going to do is excuse all of you till tomorrow morning, 9 o'clock. I just want to, as you can imagine, want to reiterate those instructions. Now you are either deliberating jurors or alternates, possibly to deliberate. So I can't stress it even more than I have for the last 5 weeks. Don't read anything about this case. Don't talk about this case with anyone, even at home. Don't listen to anything. Just put this out of your head. Come back here tomorrow morning. We'll start at 9 o'clock. What'll happen is we'll have you come in. I'll bring you in. I'll ask you those questions. I'll just turn you right around and have you back deliberating. All right? And so with that, with my thanks to everyone, excuse you till tomorrow morning. Thank you.
Court, all rise. Jurors will sit, please.
Jurors have exited the quorum. This court's in session.
All right.
Please be seated.
Anything we need to address before tomorrow? Counsel. Thank you, everyone. We'll be in recess till tomorrow. Thank you.
Court, all rise.
The fate of the 36-year-old labor and delivery nurse who killed her 3 children